Yes, please.
My lordship, my lord, this matter, motion matter and listing on my lord next Monday, my lord.
When did you file?
25/11, my lord. 25/11.
He'll come up Monday, yeah.
Monday. Obliged.
But without any defect, no?
My
No
lord.
defect.
No defect.
Okay, yes. Next.
May I please, Your Lordship? I will to mention for listing an urgent matter, my lord. Two more, my lord.
What is the urgency?
Urgency is that my lord, OT is going on, my lord.
What is going on?
One-time settlement with bank, my lord.
Acha.
The period's over by Monday, my lord. I have already paid some money, but,
It is regarding some surfacey matter.
Lordship, but I'm not
Is it surfacey matter?
certificate matter, but I'm not agree with the settlement order. I neither ERT order, just extension for time. I'm ready to pay.
Okay.
Tomorrow, my lord. Okay.
Yeah, actually, I have to mention for listening a motion matter, lordship.
What is the most what
Lordship, Wednesday. Monday or Wednesday.
what motion?
Lordship, one reference is already pending before this honorable court. Lordship, again, I have received notice from the
Okay, Wednesday.
Lordship.
Maybe I do beg to mention for listing order, my lord. In the order sheet, my lord, the petitioner supposed to appear, my lord, DSP before to Golaghat, but it was written as Jorhat, my lord. That part, my lord, only.
Wrongly written by this court or by whom?
My lord, wrongly by this court, my lord.
Huh? By
Court.
this court,
Yes, my lord.
not by you.
But
In the petition is Jorhat,
Jorhat, yes, my
And
lord. Golaghat,
court-
my lord.
Golaghat,
It is Golaghat,
and
my lord.
it is typed as Jorhat from
Jorhat,
here.
my lord.
And
Tomorrow, my lord.
so we can't impose course on the stenographer. Stenographer will say the judge has dictated, and we can't impose course on ourselves. And there is
No, my
the
lord,
immunity we have
actually,
also.
the problem is, my lord, there is no tribunal Golaghat. That is why that problem is occurred, my lord.
Okay. If the court could impose course on ourselves, then there is no provision, so we are escaped. Okay.
Hello.
No, please, Lordship. Lordship, I beg to mention for listing, Lordship. Lordship. Main writ petition is dismissed for default, Lordship. FT meter, Lordship. Now police is searching the petitioner, Lordship.
When it was dismissed,
Lordship, it was dismissed on August, in the month of August.
August. So wait, no problem. We'll see
We have
next
filed
week.
for restoration, Lordship.
Next week we'll see next week.
Next
Next week.
Obliged, Lordship.
I'm praying for listing this.
Huh? What is that matter?
Read
will
appeal,
listen.
my lord.
Huh?
Read appeal, my lord.
This appeal.
My lord.
What is the urgency?
Urgency is that, my lord, connected cases are also pending.
No, it will be listed in due course. You have filed it. No, when did you file?
It was filed on 31/10, my lord.
31 till it come out.
In the next week, my lord, any date in the next week.
Come out. That unless there is some urgency, don't mention. No, normal routine matters you mention before the appropriate bench. Unless there is something, somebody is going to be arrested, something is going to happen, then we'll take it up. That don't routine matters don't mention.
My lord, this petitioners my lord.
Doesn't matter. You make a mention on Monday before a court one. That will be better. Yes, next.
Daily list for admission, item number 1.
Prabha Devnath. What is this? Prabha Devnath. Who is the counsel? File, record, no? Why it is listed today? Notice, no petition on interim bail. Okay. Await records. Notice. I think notice has been sent. Notice has been issued. No. Was notice issued? Forecast of some more time. What? Notice. Record has. Huh? Issue reminder to the why the this we had passed the order when in March 23. Why the just let us see why the Dibrugarh FP has not sent. Seek a explanation from the border from the foreigners terminal. Dibrugarh 2nd. Dibrugarh as to why the records in respect of FP case number 2381 of 2006 has not been sent till now. Though notice was issued as far back, though this court had directed requisition of the records as far back as on 23/3/2021. Yes, next.
Item number two.
May I please, Your Lordship? My Lord, LCR received, my lord.
So we'll fix
My
it.
lord, he is in jail, my lord.
He's in jail.
Yes.
When he has been in jail.
He was arrested on 28/6/2022.
But what is so wrong with this order, impugned order?
These believe the exhibited documents.
Huh?
These believe the exhibited.
What are the exhibited documents?
My lord, kindly come to page 69, my lord,
69.
the impeachment judgment.
No, which is the document which has not been believed by the
My
tribunal?
lord, the voter list of 1971, which was exhibit as exhibit 1, my
Let
lord.
us see page
Others-
number.
Page, my lord, 25.
What is your father's name?
Father's name is, my lord, Hurmuz Ali. Here, his name has been recorded at Hurmu, my lord.
Hormu.
That has been, my lord, stated in the WS, my lord.
Hormu.
Hormu.
Otherwise, your Hormu Ali.
Yes,
Ali is
ma'am.
not mentioned.
Yes, my lord.
And what is your name?
My name is, my lord, Moinul Haq.
Where is that? Show us.
My name has been recorded in the voter list of 1997, my lord.
Where is that? Show us.
That is at page, my lord, 31.
Cheni Marigaon, same village.
Page 31.
Is Mr. Same village. Okay.
Yeah.
And Mr.
Yes, yeah.
But the father's name become Hurlus Ali. Lordship. And
Hormu.
village also different, Lordship.
Huh?
I think village name also.
No,
different.
Cheni Mari. He also Cheni Mari. You also Cheni Mari.
Yes, man.
Dekho, hard missed. We have perused the original records. Though there is some minor discrepancies as regards the name of the father, where his name has been recorded somewhere as Hormu and in other voter lists, in one voter where the petitioner's father name has been recorded as Hormuz in voter list of 1971. It has been recorded as Hormu.
Age discrepancy is also there. Lordship.
Hormu.
Yes, man.
In other voter lists of 1971 Hormu, 1971 Hormuz,
1985.
and 1985 Hormuz
Horlus.
Horlus Ali.
Yes, man.
But the Ali, but the state names appear in respect to same village and the same legislative assembly. Under the circumstances, full stop. The name of the petition also appears in the same village in the voter list of
97.
1997, along with the said Hormuz,
Yeah.
his father. Under circumstances, we are inclined to grant bail to the petitioner, who is presently in detention and on the strength of the on the basis of the opinion dated
Dated, my lord, 28/6/2022.
28/6/2022. Accordingly, the petitioner may be allowed to go on bail on production of rupees bail bond of rupees 5,000 security like amount to satisfaction the SP border Jorhat.
Golaghat, my lord.
Huh?
Golaghat.
Golaghat.
Yes, man. Tribunal is at Jorhat,
Oh,
but he is from Golaghat.
okay. SP border Golaghat. Yes. Phone number, mobile number. You have mobile number.
My lord, my
Not your Mr.
my lord, no.
You will be appearing for so many.
No, man. I do not get.
This gentleman, what is his name?
Moinul Haq. He is in jail, my lord.
But he doesn't have a mobile number.
No, my lord, I don't.
You ask him to buy a mobile,
My lord.
subscribe to and then you give that mobile number. The petitioner also, within a period of 15 days, within a period of 15 days of his release on bail, will provide his contact, his personal mobile number. Don't give the mobile number of your friend.
Yes, my lord. My lord.
And he'll go for walk somewhere else, Kerala, Karnataka. You will not be able to find your personal mobile number.
Yes,
Okay.
Oblige me.
Item number three. Orders.
Nepal Das. Yes, Mr.
Please, your lordship.
Hey.
This review petition has been filed, Lordship.
What is the first order which you are seeking review?
Review of order dated 1/10/2018,
Please,
Lordship.
please.
Page Lordship 69.
Page 69.
Yes, Lordship.
69.
Lordship, in this case, though there is some delay in filing, but as far as the COVID thing is concerned, as the Supreme Court's listing,
What? A bit.
though there is some delay in filing this review,
Yes.
but because of the COVID, that can be allowed because Supreme Court has passed an order till 22, probably
Yes,
till,
31st
March 22,
2022.
this is allowed. So
Okay, then we will not go into the merit of the
Yeah,
case.
we are not going to the
Yes, I got that.
delay part, Lordship.
Delay
Delay
part.
part is not.
Then we'll allow the review. What?
No, review that merit has to be gone through.
No, but you said COVID. What do you
No,
say
no,
COVID?
for the delay part.
Del-
For the
Okay.
delay part.
Okay,
Delay part.
oh.
I am not objecting. to
Okay,
this
okay,
because
but
the
merit, okay,
merit part.
on merit. Okay, we'll see that. Present petitioner examined himself as DW on deposit. He came from East Pakistan with his wife in the year 1962,
Yes, Lordship.
along with his brother one Gopal Chandra Das and sister-in-law. The tribunal impugned the certificate issued by Assam Muslim Federation is the only document the office could show prior to this period, and this certificate issued by a private organization. Is it by some private organization? Huh?
At that time, MP has opened up that organization.
And which when assuming OPs have said their foot in sitting down, they ought to have obtained certificate of registration. But this certificate of registration under section 1(5) of the Citizenship Act from the competent authority, you did not obtain.
My father had obtained. I have annexed along with the writ petition
Or your father had obtained.
earlier.
But then you did not
No.
file in the tribunal.
No, Lordship. That in the writ petition I have annexed.
In this present writ petition or the earlier writ petition.
Earlier writ petition,
Okay.
because records were not being called for and on the threshold that
Okay.
writ petition was dismissed. Lordship.
Unless the sale is obtained, the OP remain illegal, therefore have this censure. The other exhibits censure. And important OP have not proved the contents. I mean, go submit the final proper image, the claim the censure was not basis of. Ought not to have been discussed on. Commission, then even if the sale is not considered at all, there are no other metal to enter in the prior to. Now, we find only piece of evidence to prove them is a corruption by the survey issued by the said federation. It will be left out, the rest of the documents can be pressed. The said having private party and the survey is a duty and censure from. And that was not considered by this court. That is why it's seeking review.
But that has been
Yes,
considered. That has been
and
considered.
there-
No, what is that? What is that you, in that earlier writ petition,
Yes, Lordship.
6707,
Yes, Lordship.
you said that you have annexed it?
Yes, Lordship.
What is that?
Annexed, I have annexed along with the writ petition.
Yes,
Copy of it. Yes, Lordship.
Page 55, your Lordship will find
Page
the original. copy.
54 and page 55.
no, we have the original record with us. In that original record,
Assam Refugee Federation,
no,
a certificate of
your
registration.
your father. You
Father
said,
was annexed along with the writ petition.
which writ petition? Earlier writ petition or
see-
this is?
This is review petition 6707
Correct. 6707 in that as annexure?
as annexure 11, Lordship.
In that.
Yes, Lordship. In that particular writ petition, page 42.
42.
Yes, Lordship.
This AK Chaudhary, additional DC Kamrup. Huh?
Yes, Lordship.
Name Budhai Das. Budhai, who is Budhai Das?
Father.
Budhai Das is your father.
Yes, Lordship.
Nachin Nagar Del Kumila is 90-year-old.
Yes.
Village Durung. PS. What is village Durung?
Village Durung is under Khetri PS, outskirts of Guwahati city.
1962. Okay. Now, the learned, this court did not consider your annexure 11
Yes,
at all,
Lord. Yes. Lord.
while disposing of the repetition.
Yes, and apart from that, Lordship,
Hmm.
in that DW2 has adduced evidence.
What did the DW2 say?
DW2 say,
Huh?
may I read, Lordship, page 53.
Certificate of registration. Annexure 11 is 41. Huh? DW?
Two,
Who is
Lordship,
DW2?
my neighbor, Lordship.
Never.
Yes, Lordship.
What did he say? DW2?
I'm here, he is 56 years old.
DW2.
Yes,
Just a minute.
Lordship.
What is his
as a-
name? What is his name?
His name is Manmohan Das,
Manmohan Das.
son of Sonamoni Das.
DW2 Manmohan Das.
Yes, Lordship.
Manmohan Das. Huh?
I'm here to adduce evidence on behalf of Nepal Das. I know Nepal Das and his family as he is my neighbor. I know them well as they had landed property and are living near me since my childhood.
Hmm.
I know them. They
I
came-
heard that. I heard.
uh,
I know or heard? No.
I heard they came from Pakistan. They casted votes here.
Hmm.
So this much is his evidence.
Nepal Das. No, this
Manmohan Das,
no, and no cross examination.
no cross examination.
And Pakistan. They came from Pakistan.
Yes. At that
Pakistan existed up to
1971,
1971.
yes.
Which date?
The 24th March 1971.
Till then it was Pakistan.
Yes,
And
it's
it-
Pakistan,
East Pakistan. And it
Yes.
became Bangladesh since when?
71.
Which date?
25th of March 1971.
25th of March.
No.
Bangladesh.
Yes.
Is it correct?
71. 16 December 1971.
15 December.
Yes, 16 December. My learned senior friend had said that.
And then they will say you have crossed this. You have come after the war.
No, my
19
document says that prior to
I
1966.
heard they came from Pakistan.
Yeah.
So Pakistan will till December.
So, but my document says this, and since that they had,
Okay. Anything else? That's all submission? And
my
what
lord,
else?
and there were no references against the other petitioners.
Oh.
Because there are 4 petitioners. In the read petition, there were 5 petitioners. So in the review, only 4 came in.
And the reference was against only
Only Nepal Das.
Nepal Das.
So I would like to rely upon the judgment of this honorable court. 2019, 1 GLT 353, 2019, 1 GLT 363.
353 and 363.
363, Lordship.
That if there is no reference, then it should not be.
Yes,
Okay.
Lordship.
So these are the 3 points you want to submit. Anything else? Any
Yes,
other point?
and for collateral purpose, Lordship,
Yes.
my existence in this country can be proved through that document. Although it's a document which was being issued at that relevant point of time in the year 1963,
Which one?
Assam Refugee Federation.
Yes.
As a refugee, me, my elder brother, my wife, and my sister-in-law, 4 of us were there as a refugee. That refugee certificate, Lordship, that itself proves my existence prior to 1/1/1966. They came as a refugee. They didn't know which is the government organization for life. They had to save their life. They have taken shelter in this country. And which is in original was exhibited before the learned tribunal, Lordship.
Yes. That's all?
Yes, and evidence of DW2 is not considered at all in the critical analysis. His childhood in 1950, in 2017, he was 56. So he was born somewhere in 1961. So his childhood,
Never, this DW, how old was he?
56 in 2017, Lordship.
2017.
Yes, Lordship. So he is born in and around 1961, 61. So his childhood, 5-6 years, his existence is proved
Okay.
prior to the cutoff date.
Okay.
And if it's considered as a collateral purpose, that the document, that the vital document which he has exhibited,
Okay.
that proves itself his existence prior to 1/1/1966, Lordship.
Okay. That's all?
Yes, Lord.
Yes, Mr. Okay.
Lordship, this is not a rehearing of the matter, Lordship, first of all. So let us examine, Lordship, the grounds he has taken, Lordship.
Yes.
That has been
Yes.
taken. The grounds in the review.
Yes.
The first ground is that I'll just read out, Lordship, the grounds that has
Yes.
been taken. For that, the Honorable Learned Foreigners Tribunal dated so and so suffers from infirmity as the same has been passed without appreciation of evidences. Therefore, order dated 1/10/2018 passed in WPC and social is modified and reviewed by the ends of justice. So
What is the ground she has given?
this is a very
Page,
vague,
page,
page
page.
16, your Lordship.
16.
Page 16, suffers from infirmity as same has been passed without proper appreciation of evidences.
Hmm.
This is the first ground.
So vague.
This is a very vague statement, dear Lordship. Second ground, while passing the order dated 1/10/2018 in WPC number 6707 of 2018, the relevant records of the Learned Foreigners Tribunal pertaining to case number so and so was not considered properly. Therefore, order dated so and so is bad. This is also very vague. Nothing has been pointed out specifically in a review petition that has to be done mandatorily. The third is for while passing the order dated so and so, the certificate of registration which was issued on 6/3/1962 in favor of the father of the petitioner number 1 as per the provisions of so and so was not considered. This is incorrect. This has been considered by this honorable court in the judgment and order dated 2018. Then, your Lordship, the next
Where is
ground,
it? Where is it?
this is ground number 3, your Lordship. Ground number 3, it has been stated that this has not been considered, but this has been considered by this honorable High Court.
Where is it? Yes.
I'll just come to that little bit later on, your Lordship. I'll just read out the other grounds that then we'll go to the ground.
Okay.
Then for that, the law laid down by the honorable court is that primary and necessary ingredient or condition precedent is that reference can only be made in respect of those persons against whom inquiry is conducted. But herein in the present case, the reference against the petitioners are without any proper inquiry. Therefore, order dated so and so is bad. This is not correct here, Lordship, because I will go to the WS that they have filed before the tribunal. And there is no specific things pointed out. I mean, this is a vague statement saying that no inquiry has been made. From where is here the petitioner has found that the inquiry has not been made, nothing has been stated there. Then 5, your Lordship will find for that while passing the order dated so and so, in the learned tribunal exercised jurisdiction which was not vested on it. Therefore, the order dated so and so is bad. So which jurisdiction is not vested on this? Nothing has been stated. Nothing. For that, in view of the matter, the order dated so and so is required to be modified and reviewed for ends of justice. This is all the grounds that the petitioner has taken.
Okay.
Now, Lordship, as far as the vital document that he wants to, the petitioners wants to rely on, that is that certificate of Assam Refugee Federation. That is at page 55 of the petition, your Lordship. 58 serial number of this review petition also. So this is the original one. And 54 is the translated version, I mean, typed version. So let's see, Lordship, let us go to that judgment and order of this honorable court. The page 73, your Lordship. The tribunal wide impugn order opined the reference against the petitioners after holding as follows. critical analysis of the reference. The certificate issued by the Assam Refugee Federation dated 6/9/1963 is the only document the OPs could show their presence in Indian soil prior to the base period of 1965-66, and this certificate is issued by a private organization, which therefore cannot be made admissible as per Evidence Act 1782. Assuming the OPs have set their foot in 1963 for settling down in India, they ought to have obtained a certificate of registration, being registered as Indian citizens under Section 51A(d) of the Citizenship Act 1955 from the competent authority. Unless the said certificate is obtained, the OPs remain illegal migrants, and moreover, they have no voter list of 1995, 1965, 66, 70, 71. From the above discussion, it can be presumed that either the OPs have exhibited a fake tampered refugee certificate of 1963 or have literally entered into India after 25/3/1971. The other exhibits documents do not need any discussing, as the OPs have miserably failed to prove themselves as Indian citizens as admitted under Section 9 of the Foreigners Act 1946. And importantly, OPs have not proved the contents of the documents of the refugee certificate as is required under the law, more particularly as laid down on, by the Apex Court in Life Insurance Corporation versus another Rampal Singh and reported so and so. Then your lordship will find Ms. Ghosh submits that findings of the tribunal was not proper in as much as the claim of entry into India by the petitioner number 1 was on the basis of documentary piece of evidence, that is certificate issued by the Assam Refugee Federation dated so and so. The said certificate ought not have discarded only for the reason that the said certificate was not proved as required under the Evidence Act 1972. On the basis of the said submission, goes from the sitting aside of the impugn order. Then Mr. Kalita vehemently oppose this, then lordship will find to come to page, this can be skipped also. Then consider the submission of the learned counsel on perusal of the impugn order. We find that the only piece of evidence in order to prove the entry into India prior to cutoff period, be it 1966 or 25/7/1971 by the petitioners, is the said certificate issued by the said federation. The said document is left out beyond the purview of the consideration. The rest of the documents, even the voter list of 1977, 89 cannot be praised for rescue of the petitioners, considering the onus placed on the petitioners to discharge as per the contents of the notice mentioning the cutoff date of 25/3/1971. The certificate dated 6/9/1963, Exhibit 1, is issued by a private party which has no valid force under any provisions of law to have its presumptive evidentiary value. Under such circumstances, duty is cast upon the petitioner number 1 to prove the contents not only the certificate that is Exhibit 1, but also the Exhibit 4, 5, 6, which are certificate issued by the government. Having not done so, we are not inclined to accept the submission of Ms. Post that leaving aside Exhibit number 1, the rest of the documents ought to have been considered, giving effect to its full evidentiary value as required in order to discharge the honors of the petitioners. The petitioner number 1 has a duty cast upon him. So this is, lordship, there are others I'm skipping. So this document has been considered by this honorable court, and after consideration, this has been rejected. So now this cannot be reopened, dear lordship, because there has to be something which is palpably wrong in this judgment and order, which is apparent and which may not be fished out. So from this, lordship, this document has been considered. Now, as far as, lordship, this another contention of inquiry and reference. Inquiry and reference, for that, lordship, I'll take your lordship to the WS that they have filed. That has been annexed to this document, this review petition, your lordship. That is at page 46. So whether this can be raised at the review stage, it was not raised in the writ petition stage also. So now, before the tribunal, this WS was filed, lordship, this 2-page WS was filed there. The written statement of Nepal Das, alias Nepal Das, son of Budai Das, submitted in page 46, you lordship, got it? Page 46.
Yes.
So lordship will find paragraph 1, that the notice served upon us in which it was charged that following persons are all doubtful nationals of India, the 6 names were given there, Lordship. Then paragraph 2, that the serial number 3 Tapandas died, and so his name may be eliminated on the basis of the certificate issued by the Gavura. Then 3, Lordship will find that the charges as doubtful foreigners are false on the ground that the prosecution side had failed to run proper investigation, that the Nepal Das, Uday Das, so and so, then Kanawala Das, wife of Uday Das, enlisted in voter list so and so. The names of the Sri Nepal Das are in the voter list 1977. The names of Nepal Das Kana are enlisted. So Lordship will find on the face of the record, it is true that the above persons are not doubtful foreigners of India. They are out and out Indian nationals, and as such, so and so. So Lordship, there is no whisper of stating that there was no reference against the other person. Nothing has been stated before the trial. And this point was not taken before in the writ petition also. Now, Lordship, this matter cannot be re-argued here and reopen the whole thing before this honorable tribunals. So the grounds that I have read out, Lordship, there is no ground which will actually convince a Lordship to open up this case. If there are certain things which they need to argue, then there is a different forum, they can go for an appeal. And in this regard, your Lordship is aware of this limitations of jurisdiction of this as far as review is concerned. So in that regard, Lordship, as far as writ is concerned, Lordship, what is the jurisdiction of a review court? So in that regard, Lordship, I would like to place a couple of cases, Lordship. Though these are known cases, still, Lordship, I would like to place these cases.
Yes.
Because in my humble submission, your Lordship, this is not a re-hearing of the petition. This is a review, where this jurisdiction of this honorable court is very limited. There has to be an error which is very apparent and palpable error, and if it remains, then there will be serious miscarriage of justice will be done. In that case only, the review can be done. Now there are cases actually where we have experienced here. There are like cases which has been already settled. I mean, after 3 years they are filing the reviews. So the settled positions may not be, let's say, unsettled by reviewing this judgment. So like in that case, Lordship, I will place a couple of cases, Lordship.
Yeah.
So Lordship, jurisdiction of as far as jurisdiction and limitation of review court, that has been settled long time back.
Yes.
So Lordship, I'm sorry, I could not get a copy of SSC.
No problem.
So this is long back, Lordship. This is 1980 judgment.
Yes.
And this has been delivered by a 5 judges bench, Lordship, of the Supreme Court. And like Lordship, I will take your Lordship to page 4, wherein this judgment, Lordship, Justice Krishna Iyer was also involved. So page 4, Lordship, his judgment has been basically written by Justice Pathak, and it has been agreed by Krishna Iyer. So page 4, Lordship, will find that Krishna Iyer is saying, I agree with my learned brother Pathak, judge, both on the restrictive review jurisdiction and rejection of prayer in case subject to the qualifications made below. So I will not read out this part. I will read out that relevant portion here, Lordship. Relevant portion, Lordship, will find at page 7 here, Lordship. The page numbering is at bottom side on the
Yes,
right
we
side.
got it.
So I'll just read out here, Lordship. It is well settled that a party is not entitled to seek review of a judgment delivered by this court merely for the purpose of rehearing or fresh decision of the case. The normal principle is that a judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of a substantial and compelling character make it necessary to do so. Sarjan Singh versus State of Rajasthan, for instance, if the attention of the court is not drawn to a material statutory provision during the original hearing, the court will review its judgment. This is one point here, Lordship. GL Gupta versus DN Mehta, the court may also reopen its judgment if a manifest wrong has been done and it is necessary to pass an order to full and effective justice. Owen Mohindru versus District Judge Delhi and another, power to review its judgment has been conferred in the Supreme Court by Article 137 of the Constitution, and that the power is subject to provisions of any law made by the Parliament or rules made under Article 145. In a civil proceeding, an application for review is entertained only on ground mentioned in so-and-so rule of Code of Civil Procedure, and in criminal proceeding on the ground of an error apparent on the face of the record. But whatever the nature of the proceeding, it is beyond dispute that a review proceeding cannot be equated with original hearing of the case, and the finality of the judgment delivered by the court will not be reconsidered except where a glaring omission or patent mistake or like grave error has craved in earlier by judicial fallibility. Chandrakanta versus Sheikh Kabir. Now, besides the fact that the most of the legal material so assiduously collected and placed before us by the learned Additional Solicitor General, who has now been entrusted to appear for the respondent, was never brought to our attention when the appeals were heard. We may also examine whether the judgment suffers from an error apparent on the face of the record. Such an error exists if two or more views converge on the point. It is possible to hold that controversy can be said to admit of only one of them. In view of the adopted, if the view adopted by the court in the original judgment is possible view, having regard to what a record states, it is difficult to hold that there is an error apparent on the face of the record. So, Lordship, here it has been settled in 1980 only. This is a full bench judgment of this of the Supreme Court.
Yes.
It states that there has to be an error apparent, which is palpable, and if it remains, then there will be miscarriage, grave miscarriage of justice. As far as Lordship, this present case is concerned, I have read out the grounds. There is nothing has been pointed out where there is an error apparent exists. There is no error apparent exists to be pointed out. And this is not a rehearing process where Lordship will go back to the tribunal judgment, tribunal's opinion, and look into and reappreciate the evidence. Those cannot be done under the review jurisdiction. That has been settled in this case. So in this background, on the basis of this grounds, this review petition cannot be entertained here. Okay. This is one judgment, Lordship. Another judgment, Lordship, I'll just place before your Lordship. This is typically of a review petition filed against the judgment and order passed in a writ petition. So in writ petition also, because the writ petition, your Lordship, there is a plenary jurisdiction is there. The jurisdiction is quite vast. But here also, Lordship, as far as review petition is concerned, it has been stated by the Supreme Court how it has to be handled. So this is State of Rajasthan and Nandar versus Surendra Mehnot and others. 2014 SSC 77, page 77. So I will refer to para 21 to para 26 here.
Yes.
I'll just read out from para 20 here. Having stated so, we shall presently proceed to address whether the writ court was justified in rejecting the application for review. The order of rejection only notices that order was passed on agreement and therefore it could not be subject matter of review. Learned single judge, as it appears, did not think it appropriate to appreciate the stand of the state and passed an absolutely laconic order. 21. While dealing with the inherent powers of the High Court to review its order under 220, Article 226 of the Constitution, in Sivdev Singh versus State of Punjab, the Constitution bench observed that nothing in Article 226 of the Constitution precludes a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or correct grave and palpable errors committed by it. In Abraham Tulesar Sharma versus Arivam Pishak Sharma, two-judge bench speaking through Chinnappa Reddy judge observed thus, it is true, as observed by this court in Sivdev Singh versus State of Punjab, there is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it. But there are definite limits to the exercise of power of review. The power of review may be exercised on the discovery of a new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the person seeking the review or could not be produced by him at the time when the order was made. It may be exercised where some mistake or error apparent on the face of the record is found. It may also be exercised on any analogous ground, but it may not be exercised on the ground that decision was erroneous on merits. That would be province of Court of Appeal. A power of review is not to be confused with the appellate powers which may enable an appellate court to correct all manner of errors committed by the subordinate court. In Tungabhadra Industries versus State of AP, while dealing with the concept of review, the court opined thus, a review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. We do not consider that this furnishes a suitable occasion for dealing with this difference exhaustively or in any great detail, but it would suffice for us to say that where without an elaborate argument one could point to the error, say here is a substantial point of law which stares one in the face, and that could reasonably be no two opinions entertained about it. A clear case of error apparent on the face of the record would be made out. So a clear case of error, Lordship, this is a mandatory condition that has to be pointed out. Once a division bench of this honorable court has gone through the record, and which has gone through the opinion passed by the learned tribunal and considered it. After considering it, it has rejected it. That means it has rejected the case on the merit. So if it is rejected on the merit, it cannot be reopened in the review stage. Then in Northern India, Caterers Limited versus Governor of Delhi. This is the case, Lordship, I have referred to earlier. R.S. Pathak Justice, while speaking about jurisdictional review, observed it is beyond dispute that a review proceeding cannot be equated with the original hearing of the case, and finality of the judgment delivered by the court will not be reconsidered except where a glaring omission or patent mistake or like grave error has crept in earlier by judicial fallibility. 25. To appreciate what constitutes an error apparent on the face of the record, the observations of the court in Satyanarayan Lakshminarayan Hegre versus Mullikarjun Bhavanappa Tirumbale, an error which has to be established by long-drawn process of reasoning on points where there may conceivably be two opinions can hardly be said to be an error. So, Lordship, if there are 2 points, there is arguable things, it may not be fished out, Lordship. It has to be apparent. It can be seen by everybody. A reasonable person reading it at the first instant only would have to see it, that there is an error. So then it has to be error apparent on the face of the record, where an alleged error is far from self-evident. And if it can be established, it has to be established by a lengthy and complicated argument. Such an error cannot be cured by a writ of certiorari according to the rule governing the powers of superior court to issue such writ. So, Lordship, it cannot be re-argued. Re-arguing a matter, an opinion passed by a learned tribunal which has been considered by a division bench, of this honorable court. It was rejected. Then they're trying to re-argue this matter. They're trying to bring out the evidence which has already been considered by this honorable division bench, then re-arguing the evidence and trying to indicate to your lordship that lordship should reappreciate that those evidence that cannot be done in a review jurisdiction. That cannot be done at all. In the lordship, then lordship page 26, I'm skipping because this is regarding the facts of that particular case. So these two cases, your lordship, I'm relying on, and then lordship sitting with Justice Sanjay Mehdi has passed this order. I'll just place this judgment also, your lordship.
What is the repetition number?
So this was passed very recently, your lordship. Lordship's justice. Your lordship sitting with Justice Sanjay Mehdi, your lordship.
Repetition number.
Extra section.
We are at 13 year lordship, I'll just point out. In the instance case, we are of the opinion the findings reached by this court as recorded dated 9/4/2019. No error apparent on the face of the records are seen in the judgment. The same has been passed by taking into consideration all the relevant materials. So as far as this case is concerned, all the relevant materials were before this honorable court. This has been taken into consideration. Then lordships sitting in the division bench have taken an opinion and they have after consideration of all the materials, they have rejected the petition. Now that cannot be reopened in this review petition. So this is what lordship I would like to submit. And in view of this, the grounds lordship that I have already read out, there is no ground which can be stated that there is an error. There is something which was not before the honorable division bench while considering and like giving that judgment, passing the judgment and all that. There is nothing. So this matter cannot be re-argued again in the review jurisdiction and opened up for. There is another forum here also. They can very well go to the appellate forum. Then appellate forum, all these things can be corrected. But in this review jurisdiction also, that may not be allowed here.
What about a document which the certificate of registration of
Yes,
Budhai
lordship.
Das?
That
Huh?
has been considered, lordship.
Well,
Not considered.
Where it has been considered?
This
In which paragraph?
lordship,
Budhai Das, the certificate of registration.
the Assam Refugee Federation.
No, that is one thing. Then
is-
thereafter, they say that I could trace out.
My father,
another-
yes, that
fathers.
document was not considered.
That,
Those documents are not proved. Gambra certificates alone.
No, correct.
That
But
was
then,
not proved.
no, that you see,
Yes,
in the para, page 9 of the writ petition, original writ petition, of course.
Yes, Lord.
Original writ petition, you have an X in this review petition?
Yes. Entire writ petition with all the documents, Lordship.
They say there was certificate issued by Assam Refugee Federation, lordship.
No,
The
they
same
also,
certificate.
no, they also relied on this page, come to page 34 of the review petition.
Page 35, your lordship.
Page 34 of the review petition,
Yes, lordship.
that the para 8,
Yes, lordship.
father of the Lord Budhai Das, migrated some.
Yes.
The certificate is issued by authority 1 A.K. Chaudhary, additional deputy commissioner, Kamrup.
Yes, Lord.
That is the same.
Annexure
certificate,
11,
lordship.
was it considered by this
No,
court?
not considered, Lordship. Not considered.
Where is that?
Para 8. Internal page 9 of the.
Yes, lordship. Yes,
Ah.
lordship.
Now, the certificate of registration annexure A11. At page here, what is this? What is it?
Page 66, Lordship.
Page 66.
Is the type copy?
So what this, has the court considered this document?
No.
So this was not placed before the tribunal, your lordship.
Correct.
It was not
But
before-
it
not
was placed
before
before the
It was not
division
before the
bench.
tribunal. Yes, lordship.
But it was placed before the division bench.
Yes, Lordship. And one of my grounds is that was not considered. And may I
Okay,
reply
anyway,
to,
yes.
the submission, what was
Yes,
being
yes,
made by
yes.
my learned senior friend? So has gone
At the same time, your lordship, same document.
Yes,
May I submit?
Yes.
my friend has stated that or this honorable court, while disposing of this matter, writ petition, has gone through the records. The record of that original writ petition is here before this honorable court. Can see it was dismissed on the threshold, the day in the motion stage. Even the records were not being called for, Lordship. And even, may I finish first? Then one of the prayer in the writ petition was to provide the inquiry report, because they have applied for certified copy, they did not get it. So they have applied for the certificate, they did not get it. And a prayer was made before this honorable court, page 40, Lordship, of this review petition, where I have annexed the writ petition, to direct Foreigners Tribunal number 1, Morigao, to provide the petitioner a copy of the inquiry reports regarding the inquiry made against the petitioners. So that plea is being taken, and that writ petition was filed in the year 2000. They have, prior to that, they tried to get the certified copy of the, and even in the WS, paragraph 3, where my learned friend has gone through the WS, they have taken the plea. There is no proper investigation.
Yes.
So, my lord, from that it proves that records were not being called for by this honorable court. And so there is no reference, even the plea was taken, they have prayed for the inquiry report. And the honorable court of this high court has settled the law in the judgment was passed that 2019 on 4/1/2019. That law was being settled by this honorable court, and judgment was passed on 1/4/19.
4/1/19 or 1?
Oh, sorry, 4/1/19, Lordship, 4/1/2019 in Sudhir Roy first case.
Kim, take out the printout.
And thereafter 363.
So no inquiry and no references to different things.
So inquiry,
There is a huge difference in that inquiry and reference. They're getting confused here, Lordship. That it is there's a huge difference in that. And Lordship, if there is an application filed before the learned tribunal seeking for inquiry report, where is their application? Whether it was placed before this honorable court? Only by making a statement, an allegation.
and not allegation, prayer
It is an
was there
allegation.
before this honorable court, Lordship. Prayer was there.
Where is
Humble
an
prayer
application?
was
Where is the
there.
application of filing and asking for seeking for report?
That application, if it will be in the record itself, it's before this honorable court.
And Lordship, High Court
Yes, anything you like to say? Yes,
Yes,
that's all.
And in the impugn order also, there are many consequential directions were there.
Why, what?
Page 45, Lordship. So consequential direction by the learned tribunal.
In this review, those are irrelevant at this point
So
of time.
these were not
These
being
are elements of
considered in the writ petition. Well, because records were not called for, so whether inquiry was being done against all the petitioners and all, that were not being clarified. And prayer were also being made.
Lordship,
Yes,
So I'll just point out one thing.
Yes,
At that point of time, when this case was heard by this honorable court, Lordship, there was a consistent view taken by the honorable court that no new documents which are not placed before the tribunal will be placed will be considered. And that may be the reason why this document was not considered. Now, if there is a different view taken by a different sitting in a division bench by this honorable court, then that should have been referred to, or like they should have gone for an appeal for that. They haven't gone for appeal for that. No appeal has been filed on that. But there was a consistent view taken by this honorable court that no new documents will be considered.
We have appealed, my lord SLP, we have assailed the SLP also. And
that's
SLP.
all. Huh?
And my last humble submission will be, my lord, the person will be stateless. If this review petition is not allowed, the person will be stateless. Because he already, due to religious persecution, he has migrated from erstwhile East Pakistan and taken shelter to this country. So if this review petition is not allowed, Lordship, the person will be stateless at this, and he is a senior citizen at this old age, Lordship. So, and
For illegal immigrants, the consequences will follow, whether it's statelessness or something else,
Likho,
the consequences will follow.
and Ms. Ghosh, learned counsel for the review petitioner. Also Mr. Kolita, learned counsel for the state respondent, state, as well as सबका नाम लिखो. In this petition, petitioner has sought for review of the order, page number
Page number 69, Lordship.
review of the order dated 1/10/2018 passed by this court. And WPC number 6707/2018. Several grounds have been raised for seeking review of the aforesaid order. Firstly, it has been submitted that this court, while dismissing the challenge to the opinion of the learned foreigners tribunal dated 28/6/2017 passed in FTC case number 586/2010 by the foreigners tribunal number 1 Morigaon, did not consider a very critical document which the petitioner relied on. Petitioner or petitioners?
Petitioners.
Petitioners relied on, that is, what is that? What is that? What is that? That is the
Ground is ground 3, Lord.
no. What is that document?
Or
Document. Yes.
document is at Lordship, page 54, Lordship.
Huh?
No, Lordship, sorry. It's not 54, it's 66, Lordship, sorry. 66.
Namely, one certificate of registration issued by the additional Deputy Commissioner of Kamrup, Deed and Kamrup, Guwahati. At Guwahati, in the name of one Budhai or Budhal? Budhai Das, who the petitioners claim to be the father of the petitioner number 1.
Yes, Lord.
Petitioner number 1, who had entered India sometime in 1960,
50s.
in the 50s.
62, this is issued.
No, but when did you enter your father?
Father's 50s.
50s.
Yes.
And because of religious persecution in the erstwhile East Pakistan, and was granted a such certificate of registration. Okay, and as such, it has been submitted that the said certificate was obtained subsequently after the passing of the opinion by the learned tribunal, and as such, it will be as such the said, and as such the petition, as such denial to rely on the said document would create great prejudice to the petitioners. Also, secondly, it has been also submitted that this court also did not consider neither the tribunal nor by this court also consider very vital evidence in the form of the testimony of one. What is this page?
Page, Lordship, is that?
DW2.
Yes, page 53, Lordship.
In the form of the testimony of one
Manmohan Das.
Manmohan Das was examined as DW2, who stated that he had been knowing the petitioner number 1 Gopal Das and his family as they were his neighbors, and he knew them to possess land and their landed property. I knew that they had landed property, and he knew them since his early childhood. And he also heard that they had come from Pakistan. This, according to Ms. Ghosh, they said Manmohan Das, DW2, was about 56 years old when he gave the testimony before the Foreigners Tribunal on 3rd May 2017, which would clearly indicate that He must have been born sometime in the early 60s,
61.
early 60, which would corroborate the plea of the petitioners that their family, their family, along with their father, along with Budhai Das, had come from East Pakistan, region East Pakistan, during the aforesaid period, in which event they would be protected by law, if they have been found to have entered India before 1/1/1966, which will be proved by the aforesaid certificate of registration, which they could obtain subsequently. Full stop. The petitioners also have taken another plea before this court for seeking review, stating that while an inquiry was held against the petitioner number 1, Nepal Das, no such inquiry was held against the other remaining members of the family, and as such, and since the reference was made only against the Gopal Das, Nepal Das, no reference could have been made against the other remaining members of the family, and as to that, and accordingly, the tribunal could not have given the opinion declaring all the petitioners, including the petitioner number 1, to be foreigners, and it will be without jurisdiction. In this regard, the counsel for the petitioner has relied on decision of this court rendered in 2019 1 GLT 253, 2019 1 GLT 363. It has been further submitted that even though the learned tribunal or this court discounted the certificate issued by the Assam Refugee Federation on the ground that the said certificate was issued by a private agency and not by any instrumentality of the state, it would still go to prove that they were present, very much present in the state of Assam, which would go to show that if they were present in the state of Assam during that period, even in absence of any certificate, it would protect them in as much as they have been found to have been staying in the state of Assam during that period when the said certificate was issued. Accordingly, it has been submitted that the said certificate certainly can be used for collateral purposes of proving that they were staying in Assam, whether they were Indian citizens or not. We'll stop. Next one. Learned, in response, Mr. Kolita, learned counsel for the state, has submitted that the present review petition has been filed seeking to open a hearing, seeking a re-hearing of the entire matter, which was heard by this court, which is not within the scope of a review petition. There cannot be any re-hearing of matters which have been already heard, considered by the court, in as much as the scope of review petition is limited, which is confined to where there is error apparent on the face of the record, or where any documents or evidence had come to the knowledge of the petitioner, which he could not have obtained even after due diligence, and unless there is a absolute miscarriage of justice. In the present case, they have been submitted by Mr. Kolita that none of the aforesaid grounds exist, and as such, the review is not maintainable. Next paragraph. Mr. Kolita, further referring to the grounds taken by the petitioner in the review petition, also submits that the grounds taken are all vague. Coming to ground number 1, taken by the petitioner, that the order of the Learned Foreigners Tribunal suffers from infirmity. having passed without proper appreciation evidence is a vague ground without referring to as to which of the evidence had not been without referring since it did not refer to any specific instance of lack of proper appreciation of evidence. Similarly, the ground to taken by the petitioner that the relevant records that this court while passing the orders for to be reviewed did not refer to the relevant records, were not considered, also cannot is also a vague one. For the same reason, full stop. It has, as regards the third ground, taken that the certificate of registration which was issued on 6/3/1962 in favor of the father petition number 1 was not considered. It has been submitted that is a totally new document, which was not filed before the learned tribunal, and as such, if the learned tribunal did not consider same, this tribunal cannot be faulted with. Coming to the fourth ground, that reference can be made only in respect of persons against whom inquiry was conducted, and in the present case, no such inquiry was conducted. In the present case, no one conducted. It has been submitted that also is a very plea which should have been taken before the tribunal.
This should have been taken before the tribunal, and no material has been.
And further, no material has been also placed before the
with that regard.
tribunal or before the court
In that regard.
in that regard. Coming to the other ground taken by the review petitioners, that the tribunal had exercised jurisdiction which are not vested on it. It has not been mentioned as to which jurisdiction which was wrongly exercised by the tribunal. Another circumstance, it has been submitted that the ground here.
Lordship,
Yes,
my apologies, Lordship. Only one submission, Lordship, like I have to. Lordship, as far as Lordship, the calling for the records by this honorable court, what happens is that like all the records are basically filed with the petitions. So in many instances, Lordships are not required, or Lordship may not think it's required to call for the records. So it may not be a ground that Lordship that should be a ground for review.
Further, as regards the submission advance, the ground taken that this court did not call for records, call record, in many of the cases, the documents are already annexed to the petition, because of which the court sometimes do not call for records, and in as much as such calling of records would merely delay the proceeding, and as such, this cannot be also a ground for seeking review. In as much as the petitioner had annexed all the documents and relevant documents in the writ petition. Mr. Kolita first submits that the certificate issued by the Assam Refugees Federation was duly considered by the Foreigners Tribunal as well as by this court, and as such, no, the said certificate was not considered by the tribunal and by this court for valid legal reasons. In as much as it being a certificate issued by a private agency, it should have been proved. It should have been proved, which was not done. In any event, it has been submitted that a perusal of the written statement, which is also annexed in this petition, would show that the petitioner had not taken any of the pleas which have been sought to be taken before this court, as well as in this review petition, as well as before the court while filing the petition, so and so number. Full stop. According, it has been submitted that since the scope of review petition is limited, and no such grounds have been no such grounds seeking review has been raised, the petition is not maintainable. Full stop. Next para. Mr. Kolita in making his submission, has relied on the following decisions of the Honorable Supreme Court. Number one, Northern India Catering, Spencer versus Spencer 1982 SCC 167. Number two, State of Rajasthan versus Spencer 2014, Volume 4 of 2014, Volume 14 SCC 77. Full stop. This court also, following the aforesaid well settled law relating to law review, jurisdiction review, limited jurisdiction review jurisdiction, also referred to the decision of this court in Jamaluddin versus so review petition number 70 of 2021. Next one. Ms. Ghosh on the other hand submits that it is unfortunate that the writ petition was disposed at a motion stage without calling for the records, which is clearly evident from the fact that there is a specific prayer mentioned in the writ petition seeking for direction to seeking for a direction to call for the records. Code for records relating to the inquiry against the proceedings. The fact that this aspect also was not considered would clearly show that this court at the motion stage at the threshold had rejected the repetition, and as such it has been submitted that had this court called for the record, perhaps the irregularities could have been noticed by this court. Full stop. Further, it has been submitted that if this petition is rejected on the aforesaid technical grounds as urged by the state, the petitioners, in spite of having a genuine and reliable document to show that they have been staying in this country since the 50s, would be deprived of their citizenship as Indians and would be rendered stateless person in much as they themselves admitted that they were initially residents of Leiden, East Pakistan, but had left the country because of religious persecution and took shelter in this country. Under the circumstances, it has been submitted that in view of the serious jeopardy to which the petitioners will be put, this court may review the order passed by this court earlier, as well as and interfere with the opinion rendered by the learned foreigners tribunal. That's all. These are the submissions. That's all. Judgment reserved.
Deeply obliged, Lordship.
Yes, next.
For orders, item number 4.
Yes. Hello.
May I please, Honorable Court Miller?
Yes.
Look, the thrust of my arguments in the review, because my friend, I think, may not object to the limitation part.
Okay, earlier.
So we go on to the merits.
So initially, so initially, so though at some point of time, the issue of limitation arose about the delay in preparing this review petition. Mr. Polita, in all his fairness, has submitted that perhaps he will not harp much upon it in view of the observations made by, in view of the fact that at the relevant time, the COVID pandemic was raising this country. Therefore, it could perhaps also accounted for some of the delays which has occurred. Right?
Miller, the thrust of my arguments for the error is that I'm born as an Indian citizen.
What is that? Let us see the impugn order which you are
Miller.
seeking to review. Yes.
This is it.
You are seeking the review of the which order? Of this
My
court?
lord's order.
Please.
My Lord's order is at okay. Page 75, Miller, of the review petition R1/13.
75 is the Nagaon, this is
Nagaon
FP.
order.
But then after that, then you had approached this court for challenging this or no?
Yes, Miller.
Now, what is that order which
I'll
dismissed
just
your
bring my
petition?
lordship to that. R3 at page 102.
102. (11/6/2019).
That's right, Miller.
Hmm.
I'm with my lordship on that.
Suppose foreigners and so. In reaching the we have carefully perused the records which original. We are satisfied original was entered upon due appreciation of facts evidence. When we find no infirmity, we would observe the certiorari supervisory on refrain fail. So, what is the ground for seeking review of this order?
Milord, I was if I take my lordship to the opinion of the at page 75, they firmly agreed with the order of the 75, Milord. Suspected, the brief fact is the opposite party here in OP1 is suspected to be a foreigner of the post 25th March 1971 stream. Competent authority therefore ordered to cause an inquiry and being satisfied, etc., with the inquiry report, submitted a reference before the tribunal. Relevant time to decide the sole issue involved in the case, whether the OP above named is or not of the post 71 stream. Then thereafter, my lord, I'll come down in para 3 at page 76. In support of a claim of the Indian nationality, the OPDW1 and examination chief produced and exhibited certain documents therein. She was also cross-examined by the state. I have carefully gone through and perused the documents relied and exhibited by the OP hearing, and thereafter 1 and 2 land-related documents purportedly in the name of the father of the OPDW1, evidence in chief as DW1. In evidence, she stated it was in the year 1956, and it's a document which comes from the state of West Bengal.
Yes, please.
Milord. So the sale deed is of 1956, recorded by the tribunal as 19th of April 1956. Actually, it's registered a month earlier. I have the copy with the registration deed from the sub-registrar of Chakda.
Is it just a minute,
Circular.
let us, we have the original records. Original records? LCR? LCR? Koi? Oh, Mr. Chaudhary.
Not here. They've been called a number of
Hello.
times.
Oh, no, just a minute, it's there. Hello, yes, hello is there. It na? 7379, na?
Milord.
379.
Milord.
379, yes, hello, yes. Original is
379
there.
of 15.
Yes, yes.
Lordship, I have a small prayer.
Yes.
Before Lordship goes into it. Lordship, may kindly peruse the prayer part of this review petition.
Where part of the
This
review
Lordship.
petition?
It seems, Lordship, that trend is that the whole trial court has to be reopened and reheard and set aside. So Lordship, may kindly peruse the prayer part. Page 34, Your Lordship. May I read it?
It's actually, I think it seems to be more of the writ petitions prayer. This was
May I
prepared
read out, Your
by
Lordship?
predecessor counsel, Milord. I came into the picture after it came back from the Supreme Court. This
So
matter.
it's
But
basically.
review,
It may not have been drafted correctly by the council on record, Milord.
It's basically seeking for review of the learned tribunal's opinion, Your Lordship, which cannot be done in this.
this is like a writ petition.
It's, I think it's copied and pasted from the writ petition like it's done mostly in
Copied
these
and
days.
pasted here.
There's a problem, this is called total misuse of the computer. And computer copy paste.
It's taken.
fortunate
petition
that-
and Pasted here in the review.
Yeah.
Fortunately, our
Lawyers-
generation is not so computer savvy anymore.
Lawyers are also so busy, copy paste.
So,
But then,
So-
uh,
review has been
you had
taken
gone
away.
to Supreme Court or what?
Milord, the
Oh, I
on the
see.
Supreme Court, the order
Now,
is
One Supreme Court says that, well, let us,
Ah.
what is the Supreme Court order?
I bring my lordship to that.
The Supreme Court.
Page 105, Milord.
This
Oh,
has to be
then what did the
corrected.
Supreme Court say?
Currently,
Just
page
let
before
us
the High Court is
page
permitted
before
to
I have
approach
from the
this
approach this court again.
Again,
With liberty to file review petition before the High Court.
main order as well as order passed in the review.
Yes, this is a 20, huh?
This is a very,
120,
this order, Milord, is also has its
6120,
extended view, Milord.
6120. Then you came and filed immediately a review petition,
Milord.
but without seeking review of the order. You have not challenged the order of this. And you have not sought the review of the High
I
Court.
must fairly confess to my lord, I came in very late. After all this was filed, I was pulled in much later, Milord. So I had no idea till
In the matter of
brief
4369.
Milord.
Oh, he just somehow he has managed to mention 4369.
Milord.
First pair. In the matter of applicant 114 seeking in terms of so and so upholding arising of the impugned final judgment in the 4369 in the body, though
What is it?
in the body has mentioned, though in the prayer portion
He forgot.
he forgot that lawyers are so busy.
And
There are
grounds
the-
also, Lordship, all the grounds are a writ petition.
It seems to be.
So it may be corrected, Lordship. I don't have any objections, but it should be corrected. Because otherwise the scope of the review has been taken away.
The basic question of fact is, Milord, when the opinion of the Foreigners Tribunal is cast upon an Indian citizen.
Mr. Chaudhary, I think, just let us be a little bit also careful the procedure. You file an application
Right.
and misapplication that
Right.
because of some, I think irregularities in the pleading, it may be treated as a review in challenging and you
And
say
I
that
place the order to be.
and you said, or amendment seeking prayer, you seek the amendment of this in the main prayer because see, what Mr. Kolita is saying also correct because
Yes,
we can't give you what is not prayed for.
absolutely, Milord.
See, in I don't know, I read little bit of books, people go and pray Shivji and Ram but then they go to a specific prayer. give me this, give me promotion. Don't have only daughters, give me son. So they give you a specific. Oh, I have been suffering from cancer, par karo. They go with a specific prayer. Whether God grants or not, that is, I don't know. That is, whether you can't say, give me, just say, okay, me, I just pray. You can't say that. We have to be specific. Otherwise, God also will be confused.
Taking an umbrella
Because,
prayer.
see, God has all omnipotent. No? The God can do anything. So unless you make a specific request, the God can't grant you. Therefore, we are lesser. We are just trying to imitating. We are not. So, but then see, even for us also, unless you make a specific prayer, how do we give that relief?
Should be done.
Just make we can hear next week. Whatever
Miller,
it is, no, we
I
can
have
just.
a small request that this miscellaneous case which will be filed, Miller, because my client is in hospital at the moment, so she
No
cannot come
problem.
to sign.
The lawyer can file because
I'll take it as a prayer from the
lawyer
bench.
can file, I think, because
He'll file.
these are procedural
I'm
irregularity.
only mentioning because my friend is living by the High Court rules in front of him. He's read each and every section. of
You
that.
then one of your lawyer will say that
We'll
the
do that.
lawyer that the client is
We'll
in
do
bed.
that.
He has instructed because this because of
I'm anticipating Mr.
whatever
Kalita.
we don't want to give any advice.
No, I'm
Because you say
anticipating
that,
Mr. Kalita.
oh, this court has said so, then therefore we will be in trouble. And now everything
No,
is
no.
live stream, everything is recorded.
Absolutely. Mr.
So we don't want to make that mistake of giving any advice to counsel.
No, absolutely. Mr. I'm just anticipating Mr. Kalita's
I
possible
thought it's
objection.
prudent to.
No, I don't think
before
Kolita, he
the
also very
meeting starts.
fair. He also fair counsel. He will not go. But
Well,
then he
we'll
has
see.
pointed out something very relevant. Obviously, we can't grant the relief which you are not seeking.
Absolutely, Mr.
So after a week,
After we
okay.
deeply obliged.
List the matter after a week.
Obliged, Mr.
Item number 5.
In item number 5, my lord.
What is this? State of Assam?
Yes, my lord.
What is your
Item-
problem?
Item number 5, they have filed a objection to my explanation to the delay, my lord. Day before yesterday, they have filed one. So I'm praying for a 1 day accommodation, my lord. Tomorrow, my lord.
Monday.
Already we have filed affidavit.
I have no objection,
They have
tomorrow.
filed a reply and Lordship directed last week to file agenda. Accordingly, we have filed agenda and now.
Day before
Lordship-
yesterday, they have filed one. I have received it, my lord, but I could not prepare it.
Go through because see,
Tomorrow, my lord.
It may be taken up today, it's
No.
because it is filed in mail or.
Monday, we'll take it up.
Monday, my lord.
Lordship.
Okay, it has been submitted that Mr. Khotaniya that he received a copy of the rejoinder affidavit filed by the respondent yesterday.
Day before yesterday.
Day for yesterday, Mr. Khotaniya, day for yesterday.
Yes, my lord.
And yesterday you were busy whole day. Mr. Khotaniya, he has to very busy
Then-
lawyer.
No, my lord. That's why I'm praying for tomorrow, my lord. I am.
It is filed, Lordship.
See, they are most sought after lawyers of the state. You are mostly appearing for the state, no? Education department. I think the largest number of employees, education, no? Monday.
Lordship, this may be the last some Lordship because.
Mr.
Yes,
Khotaniya,
my
we
lord.
don't want to write this in the order,
Yes, my lord.
please, huh?
Okay.
Monday.
Okay.
Okay.
Item number 6.
Lordship, may I?
Yes, item number 6, what do you want?
May I pay for a date, Lordship?
Review, Miss Kulsum Begum, what is the review you are seeking? What? Foreigner tribunal also?
For that,
You want some other time, okay. Mr. Kolita, he wants some other time. Okay, Mr. What is your name?
B for con.
Praise for wow, how long? How long you want? You want adjournment, how long? Tell us.
Next week. And
Next week. There are so many things fixed in next week. We have given you opportunity to appear today. Because there are so many people waiting next week.
It's after vacation.
We don't know. Computer will fix it. We will see that. 6 adjournment, prayer is allowed. No date fix, will come on his own. Yes, next.
Item number 7.
Jamaluddin,
Yes,
review of what order? What is wrong with the order?
Two orders, my lord, the tribunal orders as well as my lord high court order.
No, but we must, tribunal will come later on. We must first satisfy us that the High Court has, there is a apparent
Yes,
error
page
on the
68,
face of
my
the record. Huh?
Page 68, my lord.
Page 68.
Yes. A return from Supreme Court, my lord.
Lordship,
You
here
have come
the-
from Supreme.
Here the question of limitation will come, Lordship. Delay part will come.
Delay part.
So I'll have to place before your Lordship. checking.
Supreme Court said, go and take a chance in the High Court.
Yes.
So he's taking a chance, Mr.
Page
Kolita.
68.
So Lordship, High Court order was passed in 24/9/2018. Then Lordship, SLP order was passed in 17/12/2019.
19, 17, 12.
12, yes. Sir.
Then
Then review petition is filed on 11/3/2022.
22.
Okay,
But
this
again, this COVID,
The
Yes,
COVID will not be covered because Lordship, wherever the COVID is covered, I'm not touching that. COVID will not cover because in
because by the
2000
time he was ready, then COVID came. COVID came in January, February of 20, I don't know. 20, huh?
it's in 20
February, January, February started COVID.
Started COVID, no? And
Person, my lord.
and Jamaluddin got scared because of COVID. He could not contact his lawyer also. Then what to do? COVID is dangerous.
But as far as
By
Lordship.
the time he got scared, when he saw the news,
Lordship, it started sometime in 2000, March 2020.
March.
So he had almost 4 months spent. So Lordship, I'm not, like that, Lordship may condone it, that's, Lordship
Okay.
will look into it. But Lordship, as far as the law of limitation, whether it's applicable or not, whether delay, how much delay can be condoned by this honorable court, that aspect Lordship has to see with the.
Okay, we'll note that. And what about merit?
The merit, my lord, in this case, my lord, a petitioner's father name appeared 1966-70, my lord. And
Don't argue, re-argue, you review. Let us first within the scope of review, please speak.
My lord.
This is not an appeal.
Case, my lord.
Hmm?
In this case, my lord, petitioner is a citizen of India, my lord, by birth. My lord, his father is a citizen of.
Again, you are narrating them. What is the ground for review? Please tell us.
A ground
Then
for, my lord. A ground
what
for,
is
my lord.
wrong with the honorable, this court's order that
Yes,
you
my
are
lord.
seeking?
The tribunal,
review?
my lord, did not consider the.
Again, you are going with the tribunal. What did the court did not do that you are seeking review of this court's order?
Yes, my lord.
What is wrong? What is patent illegality
Yes, my lord.
that you are seeking? What is that mistake committed by this court that you are seeking review?
So, my lord,
Or what
first,
is
my
that
lord,
gross
tribunal's order.
injustice that you are seeking to?
Oh, you have to go to first, my lord, tribunal's order, my lord, then come to my lord, high court order. my lord.
Lordship, let him go through the grounds that he has taken up. That will be easier, Lordship. Let him go.
Will come to
Grounds, my
tribunal.
lord, page 10, my lord. in my
What is the
review.
page 10 ground? Page 10, yes.
A, B, C, D.
Dismissed on trivial technical ground without making an appeal or no. Let us see the order of the court. Let us see.
65.
Page 65, my lord. High court order, page 65. High court passed this order, my lord, without calling the record, my lord, LCR, my lord. Very first day, my lord, at the motor stage, my lord.
This second week of December. We'll hear you second week of December.
13-12. Daily list over hearing list.
We'll hear the criminal matter, na? Huh? Date reference. Yes, Madam Minister, which case, which is that appeal matter which are
That is 1 to 4.
1 to 4, no? 1 to 4, that reference, no?
Yeah.
Moinul Haq. Okay, you are replying, no? Earlier, no? Or you are.
PP was.
I am libre first, and then.
Fine.
He is for enhancement, my lord. He's for enhancement.
You are enhanced.
For upholding my lord.
And there is one more Pathar matter, where only one point was there, whether
That matter.
that accused being the deaf and dumb person, whether.
But then
procedure
Vijeta was supposed to do some, yes, you have
even
got
the
some
Judgments.
judgments.
Only one thing can be done there.
Yes.
By seeing one of the judgment I've seen, since he cannot communicate, and there can be a possibility that who could have taken a defense on the facts of the case, like grave and sudden provocation, something happened prior to the incident. So, but then although 313, it was recorded, he answered with the help of a tutor, but then that is the reply that he gives to the circumstances. But he could have taken some more defense had he been able to communicate. So in that particular case, of course, all high court cases, they said he could have taken the ground of grave and sudden provocation. And so what high court did, instead of remanding, that will not be justice.
Even if that is what the Supreme Court as well, High Court say, even if you plead guilty in serious offense, court should not immediately act, because that can be because, see, 302, murder, there can be various circumstances. As you say, grave and sudden provocation, it may be without any intention, it may be just, accidental, all kind of, that has to be.
So taking that view of the matter, Supreme High Court said, High Court lessened his punishment and gave him few years punishment, and then said.
And how many years he has been already in jail?
He is inside from the day of arrest.
That is how many years?
5-6 years. Yes.
How many years?
From the date of arrest, he is behind the bar.
11, no. 2011.
He was arrested when? Investigation. FIR was lodged when?
FIR was 2011.
2011.
5/9/2011.
Around 11 years.
So 11 years, 2011 he has been there. So more than 10 years.
But in most of the cases, Lordship, the learned lower court had made a reference before the honorable, honorable high court in those cases, and as per 341, as per 341, High Court has the power to decide whether all the procedures are taken or not, Lordship. I have judgments from different courts, Lordship, and in 2-3 cases, it is there that if the offense is a previous one or whatever, only because he is a defendant, he will not get any benefit for that.
Correct.
The facts of the case has to be seen. Only what is to be looked after by the Honorable High Court is that whether all possible opportunities he had given or not, Lordship. Those were mainly discussed. And 1-2 cases, the conviction are reduced. Some cases, it is upheld, Lordship.
So
But
you have got a judgment.
I have few judgments from different high courts.
Even I have 6 cases
You have
from
got 6.
1916.
You have got a list with you.
Huh.
Now please give the list, we'll prepare and we will hear you properly.
Not
Not today, huh? Let us also have the advantage of going through it.
Huh.
And what about other foreign?
Foreign, Lordship, no.
Foreign, yeah, there is a mention about English law and American law. There, initially they used to say that he couldn't communicate, he's deaf and dumb, so he's not in his proper state of mind, so he is released.
Oh.
That was
Which-
the
which?
procedure which was followed by English courts in
Till-
the
till-
initial.
till? No, recent, contemporary or old?
No, initial stage,
Initial stage.
before
Maybe
independence,
because
1911 and all.
in
Thereafter,
foreign
it was
countries,
realized
perhaps
that no.
they followed the procedure. Maybe because of that, there are not much cases, no?
Later, English courts did not follow that. English court used to go into the merit of the case.
Where is my law clerk here?
6 judgments I've already mailed.
Huh? Hold them, what are you doing, law clerk?
6 judgments I'm
What they are
placing.
doing, huh?
I'm placing 6 judgments and I have mailed it. And
Please mail it, huh? And you take out a printout. Okay? Because this is a very interesting area as far we are concerned, because we haven't have any privilege of going through right now. We will do some, because it's an important area, because even if because deaf and dumb, even he is highly intelligent. Because whether his intelligence has been able to be transmitted in the form he wants. He understood everything. He understands. It's not that he doesn't understand. Because suppose if the incident had happened, he was there. Actually, he was there. But then what he wants to convey, what he wants to express, we don't know what is in his mind.
In one of the cases, High Court said that the session judge did not take each and every step in order to see whether he has understood the proceeding. Simply recording 313 or committal proceeding, somebody is called, that will not be enough.
Maybe one day, 2 days, but then but then whether the court is, substantially satisfied.
Hmm.
Oh, yes, though he is defendant, he understands, so I can make out from his
Yes.
demeanor. See,
From his
demeanor.
demeanor. This is
Demeanor.
important.
See, demeanor is something, even those who can speak and hear, their demeanor can be tested by the court. See, he may say something, but his demeanor says something else.
This is the word used by the High Court. His demeanor has
So
to be-
demeanor, so it becomes more important in a case of a deaf and dumb accused. Whether he has been able to express his view, because whenever in a cross-examination, he will tell his lawyer,
Hmm.
see, he is telling lies. Please cross-examine in this, because please ask in this.
Yes.
Whether, because, and if there is no cross-examination,
Hmm.
then it is not tested.
Not tested.
Cross-examination is to test the credibility, veracity, of the statement, of the evidence. Now, he's been denied that to test. Not because he doesn't want to, but perhaps he is not able to convey this to the court even.
In few high courts, in few cases, doctors were called to examine. His relatives were called to make those relevant gestures because they
And
will
in
weigh
this
better.
case, the court called the expert only in 313 statement.
Committal proceeding.
Expert knows the language.
You see so the deaf and dumb will use the medium of sign language.
Yes.
The sign language one will use except that expert when he was there. I don't know. We don't know what expert he said. He understand. That's what he said. He was present only when 313 statement was recorded.
Yes.
But before that, a substantial evidence have been recorded against him. All incriminating materials have been put to him. But he was not given the opportunity. Who will do it? Even if he doesn't do it now, it is a duty of the court
To see.
to see. Just like, see, if I think it's a part of CRPC section that if an accused is unrepresented,
Hmm.
the court will ask him, you require, there's a duty now. Now, obviously, why the court is asking this fellow, he may be, because the court feels that perhaps he may not able to understand the nuances of the court's proceeding, implications of what he will say.
How can a layman understand?
How can a defendant?
Defender.
It was the duty of the court to appoint a legal aid counsel who knows sign language.
Hmm.
We have to, I think, appoint some lawyers who know sign language also. And now it can happen. We may have to do that with the requirement because there may be cases where deaf and dumb are implicated falsely also. We don't know.
Yes. Happens.
That's what he's going to say, Madam, Visita is going to say. I have been falsely implicated. They had some other problem. These brothers had their property problem. I have been the.
In fact, Lordship, the counsel for the accused may also ask for this.
Yes.
In one of the case, it is even reflected that the order sheet, it doesn't reveal that the counsel for the accused had also sought for any such.
Even if the counsel
Here it
doesn't
is
say
not.
that, the court's duty also.
Yes, court's duty.
If the court's duty is above counsel's duty. If the court sees there is something, which is apparent, the counsel is also keeping mum. Will the court also keep mum? And how do the court use questions under section 160 of this Evidence Act to the accused?
So many questions, yes.
165 Evidence Act, the court can ask questions to find out the truth. The court, we are duty to not to uphold prosecution or uphold the appellant. We have to see what is actually happened. So in a trial court, the court has a duty also to ask questions.
Those were all given, go by.
How do you ask question with the judge also? We have not, in the Assam Judicial Service, we don't train them, sign language. Huh? How do the judges know? How do the judge convey? How the judge will ask question to this deaf and dumb? That's why we are saying it's slightly, I mean, apart from the merit of the case, obviously we'll decide, but attended to that merit of the case, this is also a very important aspect, which we have to give.
Few
Now
high courts
that-
have decided that issue.
Okay, very well.
That I have already.
Well, that's very good. So we'll go through that also, but still kindly see what is the practice, because see, in many of the, not that we are Indian judicial jurisprudence is much, we would say with all humility, we have attained a very great kind of level of sophistication, and also we have to deal with all kind of, whether we practice or not, that's a different issue. For example, JJBs, POXOs, these are some of the very advanced legislation which many countries don't have. There are so many provisions to take care of the children, so many provisions to take care of the victim, the accused, the rights of the accused, right of the victims. And so many provisions are there. Whether it is implemented properly or not, that's another issue. But at least we have been able to provide the legal framework to deal with this kind of situations. If you are giving so much, pain in a POXO case, a victim who cannot speak, not that she can speak. She can speak, but for various reasons she will not speak out. So we use educator, interpreters to make us say what actually happened.
In fact, Supreme Court have got number of cases on deaf and dumb, the victim
Therefore,
being the deaf and dumb.
Yes,
But accused being the deaf and dumb, there are no such cases.
correct.
for a
No,
Supreme
but then similar provisions have to be made for the accused also.
Yes.
Otherwise, his right will be fair trial. Fair trial, right to defend himself properly will become
Lordship's juniors, I mean.
not my
the
juniors,
officers
man. I
of-
wish you had. You know about this case now? You have, oh, they are doing some research.
Yes, yes.
Okay, very good. Oh, that's why we are discussing about this. Very good. Now, these judgments given by learned counsel for the appellant as well by the learned PP, you get it, compile it, we'll do some research for
Even
this.
made a small note on
Okay.
those judgments.
Okay.
Little facts, what they have held.
That's wonderful.
Because Lordship need not go through them.
I
the
see.
entire judgments. I'll mail it.
Okay, very good. That's good. Okay.
Then Lordship can take
Now
it
we'll
up.
hear some other day, next week or
Huh?
something like that.
Tomorrow there is another part heard, so
What tomorrow part heard? Tomorrow which part heard?
there yesterday's matter, Abhijit Paul, that was part heard. The
So
council.
visit Paul.
Council was supposed to say something more.
Oh, visit Paul, what is that?
66, I think. Part 266, no?
It's a small matter.
That he want to construct his house, that person who borrowed some money to construct his house.
Yes.
Oh, let him construct the house. We'll not,
Yes.
that we'll see that tomorrow. I don't know. Okay, we'll see that. Okay.
Then next week, this one.
And this one will next week. Huh?
Gotcha.
But if you are there, we'll call you anytime. Both of you present, huh? We'll call you because the list is valid. No, this hearing list is valid. Next week also, no. So tomorrow, because the debt reference somehow we want to
Yes.
finish it off. Then yours is not debt reference.
No.
So we want to finish off the debt reference. So next week we'll request you anytime.
We are there. Lordship. Problem.
Item number 124.
Kata দেখছে একজন কি সুন্দর
Yes, Leonard.
My lord.
Yes.
My lord, on last occasion, my lord, when my learned friends summed up their my lord, evidence, arguments, my lord, we tried to find out the sketch map from the sketch map, actually where the occurrence took place, etc. All these things, and sketch map is not very much clear. So that is why we have to my lord, take up the evidence of the investigating officer as well as sketch map to understand the entire scenario. My lord.
Okay.
Now, my lord, I beg to draw your lordship's attention to the evidence of IO. That is it. Page 47.
Page के बाद page
47. It starts from 47, my lord.
Page 47.
Yes, it starts from 47, my lord. The relevant portion your lordship will find regarding sketch map. What has been stated by him in chief. That is
Yes.
at page 48, my lord.
Abhishek is the IO, no?
Yes.
Abhishek Boro.
Sketch map on-
Bodo or Boro? Boro.
He signs as Bodo.
Oh, because Ro. In English, there is no Ro.
Right.
In English, there is no Ro. There are many
But people write as BORO.
Bodo. They write Bodo.
Same thing.
Do. So if a person who doesn't know Bodo, they will say Bodo.
Bodo.
But otherwise, it's Bodo.
Bodo.
Not Boro, Bodo. So Ro,
Ro.
in there is no word for English. Abhishek. Bodo. Page, where we read?
Page 47, my lord.
Yes, relevant para.
Relevant portion of page 48. My lord, you also may kindly take up
Yes,
this evidence along with page 278, which is
Along
the
with?
sketch map.
with the sketch map, yes.
To understand, my lord,
Yes.
this sketch map.
Page, sketch measure, page.
Page 278. my lord.
278.
2 line.
My lord, page 48, I am reading out from the beginning.